A lot of lawyers, I think, probably because the job market for lawyers is so tight recently and is projected to remain very restricted over the next several years, have decided that instead of trying to get a job or succeeding at getting a job at a firm or in a governmental entity, to start their own law firm right from the beginning, right out of law school. Or maybe sometimes they go into a small firm with one or two other lawyers who have also not that much experience, either 1 year or less or 5 years. And this is becoming more and more common. I have an increasing number of clients who have retained me to advise them about ethics issues and professional responsibility issues and law practice management issues, who are very young lawyers and just starting off on their own in an environment where not only they don't have much experience in their substantive area of law, but they don't have the experience about managing a law firm or their ethical requirements under certain circumstances. And we're seeing this much more as time goes on. There are quite a few lawyers doing this. There are a lot of things for a lawyer in that kind of situation to consider before starting a new law firm or shortly after starting one. The first is really, why are you doing it? If it's an economic reality, that's a reason, and a more and more common reason. If there are no other options, then starting a law firm can be the only thing that's available to lawyers starting their careers, and it's certainly a legitimate thing, and many of my clients are being very successful in doing this. So while daunting, it is possible to do a good job starting your own law firm with one person or maybe two or three. But there are a lot of things to think about. The first is, as I say, deciding why you're doing it. Is it a business purpose? Have you decided that for whatever reason in your area of law you think you can do better on your own? Maybe it's an environment that you think you will enjoy more than practicing at an established firm or for a governmental entity or for a corporation. So there can be a lot of reasons for it. Once you've made that decision, like anything else, it's important to have a business plan. And I think the most important thing first off is to decide where you're going to spend your money. It's going to be hard. You should count on it being difficult to build a solid client base that you can rely on. So you want to have as little overhead as possible. You don't want to invest in a lease or other requirements to pay on a monthly basis for your office space, etc., that's too expensive from what you can afford or what you can reasonably anticipate being able to afford. So you want to think about how much you're going to invest in terms of a commitment to your firm, lease, staff, other things that are related to overhead, or the equipment that you might need. Most young lawyers starting off will invest very little in terms of the kind of space they need. Some of them practice out of their homes in the beginning, or will share space or do an executive office space, something not too expensive. And we'll put actually some more money into their electronic overhead, their computer systems, their scanners, their copiers, their telephones, their smartphone, their software, everything that allows them to be connected and to have an outreach to the world. I've seen quite a bit of investment in websites right up off the front. And as long as the money is there and that's not an ongoing monthly expense that's too burdensome, those can be useful to help to start a practice. But the thing is that lawyers in this situation must remember is that if the monthly bills are so high, then the pressure is going to build. And the effect of that might be to take on clients that you really shouldn't take on, you might not be ready to take on, or as what happens very often, who are really not clients that are worthy of you. There are some expenses that are worth undertaking that are very helpful for your protection. One, of course, is malpractice insurance. In Arizona, that is not a requirement, but you do have to tell the state bar you don't have it, and then that goes on the state bar's website. It can be bad for marketing. You need to be insured for your potential errors and omissions, and you have to have good insurance for that. And you don't want to cut corners on insurance up front.